everyone, my name is Vanessa Henri, and I am an emerging technology, data governance, and cybersecurity lawyer at Fasken. I have the pleasure of hosting a panel of amazing experts today to discuss IT acquisition and concerns in the context of crisis management and resiliency. So let's begin. So COVID-19 has pushed many corporations into an accelerated digitization curve. The phenomenon of employees working from home has certainly played a significant role in this regard. But in reality, the considerations are much more diverse than that. And managers across Canada right now are faced with very difficult questions. How to improve business processes in this context? How to ensure the maximal efficiency for the lowest cost? How to ensure ongoing communication? How to ensure ongoing commercialization, and how do we do all of this without engaging our liability, and also what new risks are arising out of all this new digital world that we're exploiting to the maximum during this crisis. And the consequences are also very palpable for corporation, obviously, when it relates to both the crisis and the decision to move many of our services and business processes in the digital world. So while many are struggling as to how and if they should adopt teleworking, so we used to wonder, like, should I do that? Should I offer that to my employee? Within a day, it was not a question, it was a necessity. So corporation had to move very fast, and still today we're both corporation and us employees struggling to adapt to this new method of working. Obviously, it's easier for some that were already in the digital world, but for others, it's a very big step in a different direction that maybe they have not envisioned on the short term. And also, while all of these non-essential businesses are closed, the essential businesses have a lot of pressure to handle. Um, I'm sure if you ask the meal delivery kit, if you ask the companies that handle online orders, anything that does delivery right now, the operational pressure is extremely high. And many businesses are reinventing not only business processes, but their entire business models. And while others are discovering that their business partner may not be able to support them during COVID-19 or during crisis management, raising questions such as, what do I do with my force majeure? And within this new reality, because of the importance of IT, IT projects made their way to the board of director. They're considered very strategic project. They're considered critical project. And this also means that managers have to report directly to the BOD about how these projects are moving over time and about how valuable they are and which risks they carry. So all of this, it's a new reality that we all have to deal with. And on the one end, technologies can help corporation, but on another end, they also raise their own share of issues and concerns. But let's start with the positive for once. So I have to confess, I have seen innovation in all industries and verticals over the last few weeks, and I continue to be impressed every day. I have clients that have event planning corporation that they will come back and they somehow manage to roll out the VR technology to do their conference over a very small period of time. I've seen people use smart contracts to reduce frictions in the business processes and try to mitigate the impact of having some of these trusted partners being closed and not being able to handle the transaction. I've seen telemedicine with decentralized clinical trials. IoT capabilities are being rolled out in the manufacturing industry. And obviously, AI is everywhere. We want to take better decision. We want to do that faster. There's a lot of unknowns. We want to pull our knowledge and ask this AI to help us make better decision. And finally, drones and robotics. If we can touch people, if we can go close to them, the best way to make sure that we can continue operate and deliver for many corporations is to find drones or robotics to do it and protect the employees for health risk and consideration. So there's a lot of things IT can help, and these are examples of innovative technologies. They're examples of emerging technologies. But all kinds of technologies are being deployed, and the level of innovation really depends on the business context of each corporation and on where they want to be in 5 to 10 years. So based on this, obviously, you see a lot of benefits, right? With IT, we can increase the productivity, we can increase our operational efficiency, we can have better insights on the metrics that matters to our company. So we can know how many clients we're losing because of COVID-19, how many we're gaining, why we're losing them, do we have more fraud as a result of e-commerce? So there's a lot of benefits only to be able to better report because every numbers matter right now. There's improved capability for strategic planning. If we have more information, if we have better vision, we can do better strategic planning. It helps to do prediction. It helps to reduce cybersecurity risk. So, and we'll see that it can create some, but technologies are also used to address cybersecurity risk. It can be used to improve employees' morale. So I've seen corporations having games online with their employees. I've seen them having wine degustations online. They're looking at all kinds of ways to connect with their employees. And while technologies may be used to separate employees from each other, today it is used differently to connect them. It's used to help them with their productivity. It's used to help them talk to each other, like we're doing right now over a conference. And obviously, it also helps the corporation in general to be able to have vision on a very distributed corporation. So we're very far away from having 30 employees in one room. They're all over the province, maybe all over the country, and we need to be able to understand what they're doing, how they're doing it, and how that has changed since before. So many benefits there, but obviously you see where I'm going with this. It will also bring its own share of risk. But I want to take a time to acknowledge that all of these IT initiatives that we have right now in Canada, they speak to resiliency. They speak to a knowledge economy, because that's what we are. We're a knowledge-based economy that has adapted very fast, continues to adapt, and is willing to handle that crisis and be resilient. And I have seen companies seeing this as an opportunity to position themselves on the long term. They've been using this as a strategy to come back faster, to come back better, to come back stronger. And I think it's a question of leadership. So we hope that during this presentation, we can help you navigate these decisions as good as possible in the current situation, because there are challenges. Challenges because we have economic constraints. Most corporations don't have budget right now. They are concerned about engaging fees into technological projects, especially if they fell down the road. Maybe this is an employee we could have paid, right? Or maybe this is many employees we could have paid. So the decisions are very heavy in consequences under economic constraints. The timeline for implementation is also very short. I have seen IT projects that are usually done over 3 years being done over 3-4 days. And that will bring their own share of risk into cybersecurity, into how much risk assessment we can do, and how we can actually deploy as a minimum viable product. Most corporations are not able to follow the vendor due diligence process at the moment. There are too many steps, it's way too long, and they need to deploy extremely fast. So how do we go around our own processes that we put in place? What's a good way to do it, and should we go around them? Because if we put them there, wasn't it for a reason, right? And then there's the contract negotiation, right? It takes time. I've negotiated contracts for large corporation over months, and now it has to be done overnight. And the very question is, do I have the right technologies? just within the sphere of artificial intelligence, there are thousands of algorithms. And I've seen corporations to implement algorithms that definitely were not doing what they intended to do in the first place because they misunderstood what were the objectives. They didn't have time to scope very good the project. And this is one of the situations where we have very limited time to scope the impacts of the technology. How will that impact my corporation over 5 or 10 years? Who has time to make that assessment today? And finally, we are negotiating a contract in the middle of COVID-19. Now I think we see many provisions very differently. How do I make sure that I write a contract that's resilient so I don't face the same issue that I just faced? So these are all challenges that are shared, I think, across most corporations. You're not alone in facing this. Many corporations are facing them, and we're lucky because we have a panel of experts today that have worked with this corporation over the last weeks, have a lot of experience in dealing with many of the issues that are relevant to this challenge. And today I'm very pleased to introduce this panel. I hope they will bring you the advice and the insights that you need within their respective expertise. And at the end of our webinar, we will open the floor for questions. If we don't have time to respond to your question, because that's possible, we'll try our best to follow up, but you will also see that our contact details are on the PowerPoint at the end. Don't be shy, just reach out. It's really our pleasure to answer the question. So without further delay, I want to introduce Paula, who is a commercial lawyer at Fasken's Toronto office. She works within the firm's information technology and startup and emerging companies practice group. And prior to joining Fasken, Paula served as an in-house counsel at 2 Toronto technology companies when she gained experience in software as a service, payments, and AI. So Paula will discuss with us today the e-commerce aspect of going online. We will also talk with Ariel. Ariel is a commercial lawyer in Fasken Information Technology and Startup and Emerging Technology Practice Group. He is based in Vancouver, and he provides strategic, legal, and commercial advice to clients looking to acquire, transfer, and develop technology, whether it be software as a service, computer hardware, commercial or industrial equipment, or even consumer goods. And he does that for a wide variety of industry. And he also says that he apologizes in advance for his COVID-19 beard. And then we have Tony. Tony's going to help us today discuss and understand force majeure and other IT-specific provision that we find in agreement. Tony is a commercial lawyer. He's been dealing with technology for about 25 years so far. He's been principally acting for vendors and buyers in putting together outsource and cloud service delivery relationship. He's occasionally helping them pull them apart too. And in his work, he deals with intellectual property, privacy, e-business, commercial law, and a wide variety of business entities associated with the development, the commercialization of technology, from startup all the way to very mature businesses and even public bodies. In addition to his undergraduate degree, Tony has an MBA and a Master in Law in the Law of Business and e-business. And as a COVID-19 hermit, he is giving up on trying to grow anything of a beard that resembles Ariel's. So we welcome any comments on Ariel and Tony's beard by email after. So starting with Paula, I think one of the most urgent need of bricks and pillar establishments right now is really to go online, digitalize their sales, make sure they can continue to operate. So Paula, what key issues should e-commerce business that are selling goods and services to Canadian consumers consider at this time? And how can vendors and consumers manage the risk associated with all of these online contracts?
Thanks, Vanessa. E-commerce is one industry that has seen a surge in growth and popularity in recent months, particularly in the early days of the COVID-19 pandemic. The forced shutdown of brick and mortar stores brought an increasing number of shoppers online, essentially overnight. In the early days of the pandemic, we saw a number of existing businesses, those without an online presence, scramble to establish websites and e-commerce shops in order to adapt to changing times. This increase in user traffic to e-commerce sites and surge in demand for online ordering of goods and services has brought new challenges for vendors and customers. I'm going to discuss these issues further today. So to respond to Vanessa's specific question that she mentioned in terms of key issues that you should consider, online contracting is a key issue that vendors and consumers should be considering at this time. If you're an online vendor, now is the time to be reviewing your online terms and conditions if you haven't already done so. In this respect, there are three main questions you'll want to ask yourself, which are set out in this slide. First, your terms should be clear and should be easily understood by you, your employees, and your customers. For instance, you should disclose whether you sell products from third-party vendors. And you should also explain to customers how they can cancel or return purchases that they've made from your site. Second, you're going to want to make sure that your terms are accurate. In terms of accuracy, you'll want to ask yourself, do my terms reflect how I currently do business? You may want to consider if you've made any recent changes in your business model or launched new products, features, or services in recent months or since you first posted your terms, and whether these additions should be addressed in your terms and conditions. You should also ask yourself, after you've reviewed your terms, if they reflect the jurisdictions that you currently operate in. Maybe you've expanded to new jurisdictions since posting your terms, even within Canada. If so, it's likely that updates may be necessary. E-commerce rules and regulations vary from jurisdiction to jurisdiction, particularly if you're operating in a highly regulated industry like healthcare or financial services. If you are in a highly regulated space, you'll also want to check to see if any new regulations have come out and if they are applicable to you. Finally, in terms of accuracy, you're going to want to make sure that your terms reflect your current risk tolerance. To do so, you should double check your product warranties, disclaimers, and liability caps, and ensure that you're still comfortable with these terms as they're currently drafted. Now, the last key question as a vendor you should ask yourself is more of a practical point. You should make sure that you can actually operationalize what's set out in these terms. So you should pay special attention to commitments that you make. You should have a look at your service levels, notice periods, delivery times, and other turnaround times that may be set out in your terms. Next slide, please. So it's also important for consumers to review terms and conditions carefully. So consumers should review a vendor's standard terms and should keep a copy of those terms for their records. Now, in terms of negotiating these standard terms, most vendors will tell you, at least in the first instance, that these terms are non-negotiable. However, you may be able to amend certain standard terms through additional order forms or other ordering documents in certain instances where you have more leverage. This is particularly the case where you're seen as a valuable customer to that vendor, or you're entering into a longer term or strategic relationship with that particular vendor. Next slide, please.
So sorry to cut you off, Paula. I have a quick question. So and maybe you're going to speak to that, but can e-commerce businesses amend or otherwise make changes to their online terms or their product offering, in like specifically in light of COVID-19? Because I've personally received a number of these emails from different jurisdictions, and I think it raised question for consumer. Can they do that, and should they do that?
Thanks, Vanessa. Yeah, that's a question I've received as well. And so once you've had a review, once you've reviewed your terms and conditions, you may decide, like many others have, that certain updates are required. After doing so, you should double check the provisions in your terms that allow you to make changes and ensure you're very clear on what basis you can make modifications. For instance, do you need to provide notice to your customers before you can make a change? Or can you make changes without notice? Maybe there's some sort of a grace period before any modification that you make takes effect. So perhaps a change must be in place for 30 days before it is actually effective. Now, what if your customers don't agree with any modification you make or you intend to make? You'll want to double check your terms to see if they have the ability to terminate. And also whether those customers are entitled to any additional remedies from you in this case. Or do they simply have the ability to walk away? Next slide, please. So consumers, it's also important that you review these terms and conditions carefully to see how they allow a vendor to amend them. Can the vendor amend the terms unilaterally? What notice are you entitled to? And it's also important to be aware of how you will be informed of any updates. Will it be via email, or will updates simply be posted to a website and it's your responsibility to go and check from time to time if a change has been made? You're also going to want to be very clear on your rights and remedies generally. Do you have the right only to walk away if you disagree with a specific change, or are you entitled to something more? Finally, as more of a practical point, customers should also ensure that they've provided accurate and up-to-date contact information to online vendors, so notices and other updates are appropriately forwarded to them. Next slide, please.
So, okay, so I think that's very useful. I mean, there's a lot of consumers right now that I don't know about others, but I've been doing some online shopping, and we definitely have that tendency to say, I agree. And I think that is very useful for consumer that they should be looking at, and also an indication of what businesses should look at, because ultimately you want to build trust with your users. So if it's relevant for your user, it should be for you. And I see here you have other vendors, other issues for vendor to consider. I'd like to hear more about that, because it seems to me that it focuses a lot also on building that trust with consumer. And I think some businesses add this like a face-to-face trust, and these seems to be issues and concerns that they can use to continue that relationship with their consumers, correct?
Yes, that's right, Vanessa. So in terms of other issues, there are many, but I'm only going to touch on two key issues today. One has to do with personal information and privacy. Online vendors are likely to collect, use, and disclose personal information of their customers in order to provide certain services to them. So if you are a vendor, in addition to reviewing your standard terms and conditions, you'll also want to ensure your privacy statement is clear, accurate, and reflective of your current business practices. So essentially, you'll want to conduct the same exercise as we discussed previously with your terms, with your privacy statement, and to make sure it's up to date and accurate. In addition to reviewing and updating your public-facing terms, online vendors should also review their internal policies and make any necessary changes. Now, I'm going to touch on a couple of points where you may have made changes recently that could impact these internal policies. So you should make sure that your policies address new issues. For instance, the handling of personal information that may be relevant to your business now. For instance, do you now collect customer payment information that you didn't previously collect? If so, this should be addressed in your internal policies so your employees know how to handle this information. Second has to do with security measures and processes. So you should make sure that you have in place a comprehensive data protection policy in addition to a cookie policy that outlines what data you collect from your customers and how you store it. Along the same lines, you should also have a clear action plan on how you will respond in the event of a security breach or other security-related incident. For instance, you should be very clear on when you have to provide notice to your customers of any security-related incident, how long you have to provide that notice, and how you are going to actually provide that notice to those customers. Lastly, if you're the type of business that sends commercial electronic messages, you want to make sure that you have a CASL compliance policy in place. You should also make sure that your marketing team and other relevant employees at your company are aware of the policy and they know how to operationalize it. Specifically, these employees should know when they have to give effect to unsubscribe requests, the specific time frames in which they should do so, and consequences for not doing so. Next slide, please. So, oh, sorry, go ahead, Vanessa.
No, go ahead. I mean, I was going to ask you, because it's very interesting that this is two perspectives, right? We have the perspective of the consumer protection by comparison to the perspective we're going to have after about how do we deal in the back end with our vendors. There is a decision I think came out this morning or yesterday, and a major social media company was fined by the Bureau of Competition regarding their privacy policy. I would just like to ask, how should corporation make sure in the privacy policy that they're not misrepresenting what they do, because I would expect that many have now new software, new technologies, because they have moved online. What are one or two questions that they can ask themselves in reviewing the privacy policy? And again, I want to emphasize how important that is, because the fine that was issued is $9 million by the Bureau of Competition. And as we know, the Bureau of Competition is as large inquiry power, and we have some concerns from the audience about making sure that what they put towards consumer is actually accurate and is not going to engage their liability in terms of, do I say too much or not enough? Will too much details put me in hot water because I'm more likely to make mistake? How do you make sure that it's not misrepresenting the actual practices of corporation? And I know you have some key takeaway here, and maybe that's part of this, but because we just got the question and we just got the news this morning, I thought it was important to kind of touch base on this.
Thanks, Vanessa. Yes, I think that question ties in well with these key takeaways here, and so I'll address on a couple. I'll address some specific questions that you should ask yourself, and by answering these questions, this should inform how you go about amending your privacy statement to address how you currently do business. So again, I would say these are key takeaways particularly relevant to vendors. So consider your current business operations and ask yourself from time to time, has anything changed due to COVID-19, or more generally since you first posted your terms? So specifically, and this goes back to the question Vanessa just asked, ask yourself, are you offering new products? Are you offering new services? Or do you have any new features that did not exist at the time your terms were first posted? You should also ask yourself, are you now using any third-party suppliers that you didn't previously use? Or did you not use any third-party suppliers in the past? And these are, this is information that should be set out in your privacy statement in your terms. And finally, ask yourself, are you now collecting any personal information that you didn't previously collect? Now, I mentioned previously customer payment information and details, since more payment processing is taking place online, but this could cover other types of personal information as well. Now, finally, you should then, after asking yourself those questions, review and update your terms. And again, this review should also cover your privacy statement and your applicable internal policies so that your employees are very clear on how you currently do business and their expectations that you have of them. And as a best practice, this goes back to Vanessa's question as well, you should consider establishing a routine review process. This process will differ depending on your business, but it could be part of a more general review if that's easier for you to operationalize. Now, whatever approach you decide to take here should make sense for your business and the space that you operate in. And again, most importantly, it should be something that you can actually operationalize and follow through on.
Fantastic, Paula. Thank you. This was very useful overview. As many businesses are moving online, there are always two different concerns, right? We have what is consumer facing, and that brings all of the concern that Paula has discussed today, whether it's privacy, misrepresentation, making sure your online terms and conditions are adapted, comply with the legislation on consumer protection. But now that you got your front end, your windows where you sell in order, now comes the back end. Now comes making sure that everything you have in the back follows what you have in the front. And this kind of continues the conversation we just have on privacy and the likes, because your front end is composed of a number of technologies that may be changing, new technologies, old technologies, and these technologies are actually fueled by data. So data is the fuel of technology. If you haven't heard that before, it is absolutely true. We are talking about 2.5 quintillion bytes of data that are created each day before COVID-19. And we will see that grow as everything becomes connected to the Internet of Things. So this is how much data we're generating with our phones, with our computers. But once we're going to have our fridge generating data too, if it's not already done, that number just goes up. And this is what the technologies need. They need in order to function, just like a car needs gas. And not all data are born equal, not all data are protected equally, and not all data are of the same quality, accuracy, or availability. So when you're going to deploy your IT project, a major concern will be, what data do I have? So for example, if I want to use AI to give advice when people are shopping on my store because they cannot talk right now with my vendors. So I'm going to replace that with a technology when they're online so that on the short term I can improve myself. Well, that AI will need to eat data. So you have to make sure you have the right data for what diet that AI has. So you're going to need data that are of sufficient quality to make prediction. You're going to need data that are accurate about past event. And you're not going to need data that are available and that can be crawled into the algorithm. And that in itself is very challenging, because if you don't look at this before going on an IT project, you may spend a lot of time and money doing something that in the end you don't have the data for. And the opposite question to that is, does the algorithm fit my project? So I can have the right data that are quality, accuracy, availability, and I can think that what I need is machine learning, but maybe that's not what you need. There are different type of algorithm, from statistics all the way to machine learning. And you have to make sure that you trust your vendor, that they're suggesting to you what you need in your context. And for that, you need to know your objective. And all of this that I'm going to explain in that little data section is going to be relevant for two things. It's going to be relevant for what Paula just explained about consumers, because all of this will need to be reflected in the document she just discussed. So if you have a new AI that uses machine learning, you will have to make sure that your terms and conditions maybe protect you against the decision that this AI can do. Make sure that you comply with the legislation surrounding that data processing, because maybe you will have personal information, and you'll make sure that your privacy policy reflects that you're using their personal data to make prediction about the clothes that will fit them the most, or about the cars that's the best for them. So there is everything we're explaining today is entirely interconnected. And on the one end, your front end needs to reflect your data processing, but also your agreements that you will have with the vendors. And we'll get there as well with Ariel and Tony. Within data, there are data that are regulated and data that are not regulated. Data that are regulated are those that have protection under legislation. So obviously, personal information is one of these data that are regulated. There are a regulation that says why you can collect it, and if you collect it, on which basis. So if you have the consent to collect data for payment purposes, you don't have the consent to analyze the data and create business intelligence with it. So it's really important to understand why you're collecting the data and what consent do you have for that data before you embark on that new IT project, because maybe you cannot use the data for this. So regulated data, you need to pay particular attention, because there are rules to follow on how you go about with your IT project with that. And if you don't follow them, there are very tangible consequences, ranging from fines to lawsuits, and there are extraterritorial legislation that may apply to these data, so you may get sued in more than one location. So personal information in particular, you need to be very careful when you're planning your IT project and you're planning your digital transformation around this. But it's not the only sensitive data. We also have what we call confidential data. So confidential data are not necessarily regulated. They are, however, subject to contractual provisions that are today well known. So non-disclosure agreement, confidentiality agreement, aim to protect confidential information. They can include trade secrets, intellectual property, your marketing plan for the next 5 years, an analysis of how well or not well you're doing during COVID-19. So all of these are data that can be used for a number of reasons, and they usually have an economic value. That's why we protect them. So we will protect the secret sauce to our recipe. We will protect our financials, because we don't want them to end up in the news, because this can reflect on ourselves. They can reflect on some practices we have. And generally speaking, both personal information and confidential data today have a value. So there are organizations, there are companies that are but entirely based on the amount of data that they have. So it's a value that we're still struggling today on how to put that on the term sheet. But keep in mind that these are assets and you need to manage them like assets. The same way you manage your buildings, the same way you manage your employees, you need to manage your data. And I'm explaining this because many of your IT projects will require that type of understanding as to what fuel I'm putting it into my IT project, even if we're doing that very fast for COVID-19. Because the truth is, you cannot afford to make a mistake at the data selection and data understanding place, because these are the foundation of the entire project, and you may have to redo the entire project if you have not understood this. And obviously that leads to the next point. We've discussed the privacy policy that's consumer facing, but when you create this project, you haven't yet changed your privacy policy, but you should be anticipating, what expectations of privacy am I going to deal with? Is this something that's going to shock my user? Is this something that's going to shock my employees? Do they have a high expectation of privacy when they're shopping online, when they're in the office? Because maybe your subject are your employees, right? And it's very important you understand that, because your stakeholder and the trust you have with them is the glue to your corporation. If you lose that trust, it will be extremely hard to get through a crisis, because the users will not follow your lead. They will mistrust you. They won't believe the information you're sharing after. And that trust is very important to navigate the crisis, making sure that they believe you. So when you think about expectation of privacy, um, in a perfect world, we would do privacy impact assessment to quantify that. Today, you may not have time for this, but at least try to do it in your head. Try to exchange a few emails with your colleague. How would you feel if I was to do that? What would be your concern? Try to anticipate so that you can build from the design a project that addresses this concern. And one of these concerns is obviously the legal consideration. And I'm going to put on the side that there's also a cultural concern. If you're multinational, keep in mind not every country, not every region, not every jurisdiction have the same approach to privacy. They may see that differently, they may see that as a core value, or they may think that in certain sphere, they're fine with data analysis. So you have to take that into consideration when you do an IT project. You have to take the legal consideration. I want to bring to your attention that there are many authorities that have issued COVID-19 specific guidance, whether it's in the European Union, in Canada, the Office of the Privacy Commissioner did, the Commission d'accès à l'information in Quebec did. In the United States, there's the EPA legislation. There was a notification and enforcement discretion for telehealth to allow these industries to deploy as fast as possible so that they don't have to go through the very complex project of selecting a vendor that is EPA compliant. So there may be opportunities for you to go faster around some of these legislation, but be careful about the boomerang, right? These enforcement discretion will not be forever. At some point, you'll have to bounce back. These are tools to help you deploy faster. They're not tools to help you manage your businesses over the next 20 years. But you need to know them because that may allow you to deploy without breaching legislation. You will need to consider contractual commitment. You may have put in a contract that you wouldn't use data for X or Y. You may have put in a contract that you don't use that, you don't conduct marketing on aggregated data, and now you may see that as a need. You may have service level agreement into your contract with your clients, and maybe that will be affected by the new technologies. Finally, you have your own policies. So if you have a complex process for vendor due diligence, you may need to get a derogation from your board of directors to go around it faster. And why I'm explaining all of this is that the core of these legislation, these contracts, these internal processes, they serve to reduce risk. They have a purpose. You know, it's not something we put in place just for the fun to make everything bureaucratic and very long. And one of these purposes is to make sure the data that you fuel into the technology stays secure. So it's confidential, it has integrity, and it is available. That's extremely important because I just explained that data has a huge economic value for you and it's regulated. If you lose your data, not only will you affect your reputation, but you may lose shareholders, you may lose value. And we have seen company close entirely following security incident. There was a ransomware a few weeks ago that closed an entire startup because they couldn't access their source code anymore. So these are very tangible threats. They're not anymore in the field of cyberpunk literature. These are day-to-day issues we see with both our clients and with organizations around the world. These are the type of thing we usually do when we pick an IT vendor for this type of project. We'll do a privacy impact assessment, maybe an algorithmic impact assessment, a security risk assessment. We'll make sure they implement the right controls. We'll put a plan. We'll follow up with them. We'll make an audit before taking this vendor. We'll identify any residual risk. We'll see if we can mitigate them in our back end if the vendor cannot do it. We'll look at the encryption methodologies. We'll maybe do a technical testing too before we go live. So maybe we'll pay an ethical hacker to try and get in and see if they can, and make sure that they cannot before we go into production with the new IT system. Now, all you can see, doing this within a day or two is extremely challenging. especially so for small and medium enterprise. So if we cannot be risk-based, we can be proactive. So we need to manage the risk. We may not be able to do it um, eventually, immediately. We may not be able to fill our Excels that have like a billion tabs and a very long, complex processes. But maybe we can write an email and say, I looked at the technology. These are some of the concerns I have. It may not be perfect, but try to document it and formally so you remember when to go back to. You can show your stakeholder that you've done what you could in the circumstances. Try to get feedback from other customer, from the industry. If you can do your own risk assessment, do you know somebody that has does something similar? Do you know somebody that's working with them? Can you have some feedback? Do they have their own documents maybe online you can leverage? How can you do what you do usually, but much faster by using information that you either have or you can have? That's one of the strategy. Maybe you want to use your contract to have more extensive audit right in the future. So if you don't have time to do it today, can you do it in the future? Can I audit your data governance in the future? I want to be reassured. And if you don't pass my audit, what's going to happen? Can I have a proof of concept so I can have time to assess the risk while we're deploying? Can I have a termination clause if you don't have a good cybersecurity after all? And eventually, this will allow you to manage the risk, but it's not a way to bypass your system. You will have to go back to it in due time. So put yourself a reminder that maybe in 6 months, maybe in a year, you're going to have to go through that risk assessment. You're going to have to make sure that what you put in place is resilient. So my message in terms of data governance, and I think that's going to continue into the choice of technology, the contract, is that if you cannot be risk-based today, try to at least be proactive. Try to not close too many doors down the line with your vendor so that you can turn around quickly if it turns out there wasn't the right approach. And finally, what I did here is I put a series of questions you can ask yourself, and formally, even if you cannot fill your entire due diligence process. Question that you should ask yourself as soon as possible when doing your project. So for example, and you're going to do your project most likely with a vendor, or at least with some technologies, right? You're going to need some software. The first thing you want to ask yourself when you work with a vendor that you have to hire very, very fast and deploy very, very fast is what support do they offer? Should I consider an end solution if I cannot support myself, right? The support from your vendor is critical right now. You are under limited resources and you must deploy very fast. And you may have to make adjustment as the plane is flying. As we say, building the wings as the plane is flying, that's what's going to happen with most corporations the next few weeks. So make sure that you have the support. Make sure that they're open the same hours you open. If you take an overseas company to support you, make sure it's the same hours than you. And make sure that the time to respond is acceptable to you. If you look at implementation, um, how is that going to work? Because they can't come to your office. Maybe you can't even go to your office. How are they going to implement right now the technology for you? Is it doable? What type of security measure do they have? Can they see my data when it goes through their system, or is it encrypted? That's a one high level question that addresses a lot of risk. And what are the prerequisites to use the technology? Do you need to have an operating system that is maybe more recent than what you want? Because that will save you a lot of time if you understand the prerequisite and you don't have them. You won't go through a whole contract negotiation. So quick question, ask them at the right time, look at it, and make your decision based on this. It doesn't replace vendor due diligence, but it does help making sure that you have the right technology, you have the right contract, you have the right concerns in mind. And you can document this question in an email, and it's at least going to give you kind of something to build on over time. These are more data specific questions. One of them is the availability of data. So that can be through service level agreement, but it can also be through making sure that you have the right processes in place for the data to be available. Business continuity, and I think, Tony, you're going to touch base on this, but I think everybody sees how important that is right now. If you're getting a vendor to support you during a crisis, you need your vendor to make it through the crisis. And for that, they need to show you that they're able to do so, that they have plans for every things that could occur as a result of COVID-19 or other crises we may have in the future. One of them is, what are they going to do if all their employees are sick? Can they still support you? And if they cannot, what's your plan B? Because if it's a core technology to your project, what's the plan B? And these are questions we should always ask, but now more than ever. Finally, make sure you understand the data flow. Just ask, where do you collect it? Where do you store it? Where do you disclose it? To whom and why? These little questions will go a long way into helping you understand where your data are going to go and whether you're comfortable with your data going there. And obviously that brings me to the last point. So often I have seen contracts that were not addressing the technologies that are sold. Old contracts are product-based, where we're delivering software as a service, or software as a service contracts that should have been licensing, non-disclosure agreement that should have been personal data processing agreement. All the different types of data bring their different consideration. Intellectual property is not protected like personal information. If you look at your confidentiality clause, the exclusions do not match the exclusion of the personal data legislation. So a personal data does not stop to be confidential because it's in the public domain, but confidential information does. You can't mix the two systems together. It leads to incongruities. Synthetic data, they're made from different ways and they can or cannot have personal information in it. So all of these considerations will drag different contractual provision. And that's important because down the line, the contract is something that's going to be hard to renegotiate. So as long as you get your contract right, as long as you open the right door in the contract and you don't close the wrong door, you will be able to continue building as you go. But if you don't build the contract in the right way, you will not have negotiation power to go back into the contract in 3-4 months once everything is deployed. So that's very important. And it brings me into more technical consideration. For example, I always hear AI is about garbage in, garbage out. Yes, but what does that look like in a contract? How do I get the right indemnification, warranties, and representation around this? How do I make my client, let's say, understand that this is a risk I cannot address? So these are technological considerations that must be understood when you're doing a contract. And these are added value expertise that are worth considering for these very emerging technologies. These are not day-to-day contracts that you're dealing with. And that brings me to the next consideration, and I will hand over the presentation to Ariel for that, because I think it's such a fascinating subject that we have seen in the news more and more lately, is the use of open source software. And why do I say it's been in the news? Is because we are, around the world, as you would know, building so many of these contact tracing applications. And in several jurisdictions, like France and Australia, the requirement for corporations to deploy this at the national level is to make sure that their software are open. And that raises a lot of questions. Why? Is it a good idea? How do I contract for that? So there are very specific considerations. And based on this, I would like, Ariel, if you could walk us through this, make us understand, should we do that? And if we do that, what are the concerns? I think this is something that we've been taking for granted for quite some time. So your explanation will be most welcome.
Thanks, Vanessa. Yes, happy to do a walkthrough of that. Just before I move on to open source, I think you had said something earlier that struck a chord for me on the guidance that has come out from privacy authorities in terms of adjusting to the COVID-19 world. In BC, we have a very unique situation where our public bodies are, with very few exceptions, unable to transfer their data or have their data stored outside of Canada. And so recognizing that COVID-19 is an emergency right now, they've come in and the government has issued an order that has provided a temporary exemption from that rule when you're trying to address COVID-19 related issues. And there's a bunch of different examples that have happened there. I think the important thing to remember, though, is at least COVID-19, hopefully, we all hope and pray, is temporary in nature. And these orders are also temporary in nature. These exemptions are also temporary in nature. So I think we should just keep that in the back of our mind when we are relying on these exemptions and tools that have been provided to us and options that have been provided to us, that they may actually not be permanent, and you should contract and realize that that's a risk when you're relying on them. So sorry about the segue away from my open source topic. I'll go back to what I'm supposed to talk about. I've divided my presentation into 4 different core questions. The first is very basic, and it's on the screen right now. It's what is open source software? And this is, I won't take up very much time on this part, because I would assume that a lot of our attendees have a basic understanding of open source, but I just wanted to set the stage. So at its core, open source software is a concept, and open source is a concept of publicly accessible. And by that, I mean publicly accessible for 3 purposes. One, for using the open source code or software or tool, so no restrictions on use. Secondly, for modification, you should be able to take that open source code and make derivative works from it, or tinker around with the code in a way that I don't understand as a lawyer, but the technical people on our technical attendees probably understand a lot better than me, but modify that code for other purposes. And then third, distribute. So you should be free to distribute the actual code itself without any modification. You can distribute it to other people without restrictions. Only restriction is if you're not modifying, you'd want to, or you'd almost certainly be required to make it available to others under the same license terms, the same open source license. But also you have the ability to distribute, with some exceptions I'll get into later, and some conditions I'll get into later, the ability to distribute the modified derivative works that you create using that open source code. So again, what is open source? The Open Source Initiative, they published an open source definition quite a while ago, and it includes a number of different requirements for what would constitute open source in their mind. But I'm really just going to focus on 3 of them. There's 10 in total. Much of them are sort of theoretical or sort of philosophical points, but these are sort of the key ones, I think, from a legal perspective. So 1, requiring free distribution. If you're truly open source software, then there shouldn't be any royalties or licensing fees charged for using that. Secondly, there's a requirement for distribution in source code. So you need to provide the actual source code to that software as opposed to just the object code. And then lastly, you need to permit modifications and derived works of that open source software. So very similar to sort of the concepts described above in sort of the publicly accessible factor. Now you contrast that with proprietary software. You have proprietary software, you typically will make it available for a fee. You don't have to disclose the source code. In fact, you almost certainly wouldn't disclose the source code unless you're compelled to. So just object code only, and generally no right of your users to modify or create derivative works. And you would create those restrictions in your contract with your customer. So the second question I wanted to talk about today is why is open source being seen today as a critical tool to addressing issues caused by COVID-19? So I'll start with sort of the broader question of why open source in general. Why do we use open source code? Why don't we just use proprietary software? Shouldn't we be protecting everything we create? The concept really revolves around avoiding having to reinvent the wheel. There's a myriad of open source code that's been developed, or code out there that's been developed and has been used. It's not particularly valuable in and of itself, but it's an incredibly important tool to be able to leverage to create new solutions. So you think of the open source community as a group that works together to allow access to existing solutions for free so that we can create a better world and better code going forward. And you can potentially commercialize that code going forward as well for that solution. And then a key part is in the open source community, collaboration is encouraged. So it's not simply, I mean, this does happen, but certainly the goal of the open source communities are not to have people go off, develop a piece of code, put it onto GitHub, and then let other people use it without ever modifying it over time. It's very much a creature of iteration. So you develop open source code, you make it available under an open source license, and you encourage collaboration with other developers in the goal of improving the software, making it more efficient, making it do things that you didn't think were possible before, and create derivative works or modifications or improvements that do different things with that software. Next slide, please. So again, why open source? Now this one is why open source for COVID-19? Well, as a global pandemic, COVID-19 has had an immense impact on nearly every facet of our life. We're working from home, we're needing to know who has the virus around us. We need to develop vaccines, we need to develop scanning technologies, we need to be able to buy goods online because we can't go to stores. Everything that Vanessa has mentioned to date and Paula mentioned with e-commerce, these are basically creating a new normal, and you've heard that phrase a lot, and it's certainly true. So, and these changes have happened rapidly, and that's, I think, a very key point. So why open source? Why is that the tool that can be used to solve COVID-19 issues or address them faster? Well, it's simply down to the scale and speed of COVID-19's impact. So it's very important that we have an equally large scale and fast-paced response, and open source can facilitate that. Next slide, please. So I'll just touch on three key points why I think open source has been sort of designated as this useful tool in technology to be able to address these issues. So first, key one is reduction in time. When we collaborate together, when the developer community collaborates together, is able to access existing code to iterate and create new improvements, that creates efficiencies of scale. It allows us to reduce the amount of time necessary to deploy and develop solutions. And this is important because we simply don't have time to wait for individual entities to create and distribute solutions completely on their own. We want to make sure that existing and newly developed code is available to others via open source licenses, so that this can create a quicker turnaround to develop new technologies. Secondly, we want better solutions. Today, or sort of in the early days of COVID-19, we didn't have a solution that was viable for being able to have contact tracing knowledge distributed not just to the health authorities, but also to individuals, so they can know, which areas are COVID-19 free, which are no-go zones. we have this with open source code, we can reduce barriers on collaboration, and that should and hopefully will have a result of better solutions than what we would have otherwise developed if everything was just kept proprietary. So the goal of open source is, again, to reduce barriers, promote, increase collaboration at the development stage, and then this can foster more rapid development and improvement. And then the last point is making sure that open source is available, or making sure that these solutions are available to those without financial means and can be widely distributed. So individuals, but also organizations and entities may not have the financial means to purchase off-the-shelf solutions or customized solutions that would typically be made available under commercial licenses. And so we should make sure that and as Vanessa has mentioned, health authorities have and governments have in some cases required this to make sure that solutions aren't just made available under commercially available software licenses. If there's a public interest in these goods or these solutions, they should be open source so that they can easily get distributed to the people who need them. Next slide, please. So now, what are some unique considerations that we should be aware of when contracting for IT solutions that utilize open source code? I'm just going to focus on two of these considerations, but I hope that they're I think that they're the most significant, and hopefully they'll be the most useful to you today. So the first is the concept of limitations of liability, warranty disclaimers, limit or no indemnification, all that lovely legal boilerplate that exists to reduce liability and reduce risk. So importantly, if I'm going to be utilizing an open source solution, or I'm going to be marketing or making available my software through open source, as the provider, I'm going to want to limit my liability as much as possible, because I'm not necessarily able to, one, benefit from, if I'm making it available pure open source, I'm not able to realize any financial benefit, so why should I take on the financial risk of that open source code? But also, if I'm utilizing existing open source code as a component in my solution, I need to make sure that I'm not going to be liable if that open source component has a defect, even if that defect is so significant that it causes my entire solution to go down. So it's very typical for vendors and providers to exclude open source components that are included in commercial software, to exclude them from the scope of warranties and liabilities, as well as also limiting indemnification obligations or completely disclaiming indemnification obligations with respect to those open source components. And again, if the solution is completely open source, the provider will likely seek to broadly disclaim all warranties, exclude all liability, and not provide indemnification. So a key consideration here is, if you are going to be procuring a solution that includes open source software, I think the first thing to know is, one, you should, in your contract, you should make sure you've identified and required the vendor to either disclose that they're including open source components into the solution, potentially provide you with copies of the licenses, and I'll get into why that's important, that relate to those open source components, and notify you or provide some level of disclosure if new open source components are incorporated into future versions of the software. And the reason for that is because you want to be able to verify whether or not, sort of, what's the scope of the open source that's included in, and then figure out what the impact would be of the consequences of a defect in the solution being caused by that open source. So some of the questions you need to answer or ask yourself, because you can't rely on the typical warranties and indemnifications and liability options that you would typically have for commercial software. You need to shoulder some of the burden of the risk on your own yourself, and so you should think about things like, can you test that solution before it goes live to make sure it actually does what you want it to do? Once it goes live, can you self-support it if necessary? So if the open source code has a bug, can you go in and fix the problem yourself, or can you access the resources to fix the problem yourself? And then the other thing you should consider is whether or not you can pass on those same disclaimers, same limitations of liability that your vendor is relying on. If you have a business that's if you're a business that then goes on and sells or makes that solution available or utilize that solution in future services for your own customers or end users, can you pass on those same disclaimers and liability exclusions to your customers and end users? And I would suggest that if you can do that, you certainly should. You shouldn't shoulder the risk of utilizing an open source of your own suppliers utilizing an open source component. Next slide, please. So the second unique contracting consideration that I want to touch on was copyleft licenses. So importantly, I think we should all know, and hopefully you know by now, that open source licenses are not all created equal. There are a myriad of different open source licenses in use. There's a few common ones, but there are, frankly, every year a bunch of new ones pop up, and you'd be surprised at what's contained in them. And so when I talk about copyleft licenses, I'm talking about open source licenses that may impose obligations on the user. So if you utilize that underlying open source code, or you utilize the open source software by itself or as a component in other solutions, there may be obligations on you. And certainly obligations on you if you seek to distribute that open source component to third parties. So one of those obligations could be the obligation to disclose the source code in derived works that you create utilizing the original open source component. But the second thing could also be providing an obligation for you to provide those derived works or derivative works to others for free. Which would limit your rights to commercialize the software you've spent so much time, or the solution you've spent so much time developing and so much cost developing potentially. So what are some considerations here? I think a key one is make sure that you review and understand the terms of the specific open source licenses that apply to the solutions that are being made available to your organization. Or the ones that you're using yourself in the products that you're then selling to third parties. There's in the open source licensing world, there's licenses that are generally viewed as permissive, and then there's licenses that are generally viewed as copyleft. So just as a basic point, permissive licenses are generally favorable. They allow for open source to be used without attaching open source licensing terms to that resulting work. And then there's copyleft licenses that could create potential impact. I think you need to think about, what the impact could be: vulnerability to your own proprietary technology, but it also could put you offside in your other supplier contracts. Next slide, please. So I'm going to try to go quickly on this because I think I'm running short on time, but I just wanted to mention a few open source initiatives that are in process today. So there's the Open COVID Pledge, and this is an initiative to open source patents and other IPs that are held by a wide variety of universities, companies, and others. Pledgers include Amazon, Facebook, Intel, IBM, Microsoft, etc. So almost all of the big players in technology today are making available their patents and IP for free on a temporary basis to create solutions to address the COVID-19 pandemic. There's also a different initiative known as the Open Source COVID-19 Medical Supplies Initiative, which is seeking to open source and develop, review, and distribute open source designs for medical supplies, which could then be used by manufacturers and makers to provide those supplies which have been vetted directly to hospitals and health authorities. And then lastly, some companies are taking sort of more specific, making specific commitments or doing specific things on their own. Pfizer, as an example, has made a commitment to make its tools available to the broader scientific community via open source. But also there's local projects like the University of Waterloo collaborating with Darwin AI to develop the COVID-Net project, which is seeking to detect infections from chest x-rays, and they're making it available on an open source basis.
Thank you so much, Ariel. That's super useful. And we also see why there would be a preference by the public authority to use open source software. There's a lot to say about avoiding vendor locks. There's also a lot to say about information security, because when a code is public, you can see where's the data going, right? You can see what are the sharing protocols, you can see whether there are security issues, whether patches should be issued. And it was one of the points that came out in the privacy impact assessment in France, is that the government, if they're going to sponsor an app, should make that public, but should also consider any feedback from the industry on the code. So it helps to build that trust. Now, whether it's appropriate for private corporation, raise a different set of issues that I think you've also covered very well. And it's also a set of contractual issue, like you mentioned, explains a lot about some of the exclusion that we've seen in the recent contract. And going back to the contract, I really want to touch base on force majeure again with Tony. And the reason why we've decided to touch base, because we do know, we are currently aware that there are many, many blogs that have been posted, bulletins, and discussion around this. I think it's been quite some time that the lawyers haven't spent so much time discussing force majeure, actually. But now it's been, about 8 weeks that we've been discussing it. So what have we learned in the last 8 weeks? What have we learned? What can we do better? And what does that mean for the contracts that you're drafting now? Because we focus so much on how do we interpret the past one. But now, what are the best practices moving forward? What is force majeure? And how is that relevant for your IT acquisition? And this is the angle I would like you, Tony, to present us with, and your expertise and everything you've been through in the last few weeks with your clients. How did that go? What can we do better? And how is our knowledge of force majeure better now?
Well, thanks, Vanessa. And you're absolutely right. I think force majeure is a clause that is often forgotten. It's usually found at the end of a contract under the miscellaneous section, not often deeply discussed during negotiation of agreements, but and actually doesn't have extensive judicial review. So there's not a lot of guidance from the courts as to how it's interpreted or applied. But we thought it would be worthwhile taking a look at some of the contractual provisions that you're going to find in any sort of agreement related to technology, be it a large outsourcing agreement or a software as a service agreement, a subscription agreement, and to just hit on some of those items that would usually be negotiated, but in the context of something like a pandemic that we're facing right now, will have certainly nuances that need to take extra time and care and caution. And certainly the most important of these, I think, would be the force majeure clause. I was involved in a large outsourcing negotiation that actually finished up after everybody had gone home, and we were doing this online. And certainly the force majeure provision, which was discussed but not extensively, came back into the fold, and the question arose: can the vendor in this case actually perform? Are we going to sign a contract and have our counterparty immediately declare force majeure? What's the impacts of this particular procurement and what's required to make it go in the environment of a pandemic, where people are running operations very different than what they had first anticipated? So what force majeure essentially is the parties' agreement that during the term of a contract there may be things that arise that they either cannot fully anticipate the consequences are, or just decide not to try to contract towards. Too much complexity, too much unknown, can't capture it in a contract in terms of I shall, you shall. in the event a particular event arises. It's the party's acknowledgement that there's a bridge too far and that there are riverbanks to their obligations. Something will change so profoundly that each party agrees that the other party is allowed some relief, typically suspension or termination of the contract. What makes tech contracts really unique is that fundamentally important to most of the tech offerings and the delivery of functionality to the enterprise is the idea of redundancy, and that failure is not an option. And so in virtually every agreement, you will see a business continuity clause, disaster recovery, and these can be very, very extensive. That's not usual in a commercial arrangement. Usually it's an obligation on both sides and a riverbank that's put out in the force majeure clause. Technology contracts have to anticipate the worst case scenario, and they do. Next slide, if you could, thank you. The doctrine of frustration really provides some of the underpinning to the concept of force majeure. This is common law developed by the courts that provide a safety net to contracting parties. Again, an acknowledgement that something could happen over time that makes what the parties had originally agreed to next to nonsensical. The doctrine of frustration can have some utility if your contract, if you're struggling as a business or you have suppliers that are struggling, if there is no force majeure clause, the doctrine is there and available to leverage to perhaps give you a remedy that might not exist without it. Or if your force majeure clause is too narrow, the doctrine may be there to utilize. However, it's a really blunt instrument. The typical remedy is just the remedy of termination of the agreement and allowing the parties to get out of that arrangement and live for another day. And you can see on your screen the tests that the courts have applied. You need a supervening event that without fault of either of the party has arisen, and it's not addressed in the contract. So there's no if this, then this kind of provision that anticipates that event occurring, and that the contract becomes something of a nonsense if you were to continue it on the changed circumstance. You should also be aware that most provinces have something called the Frustrated Transactions Act, the Frustrated Transactions Act, so that that piece of legislation should be referred to. It may give broader remedies than just the remedy of termination. So something to keep in mind if you end up in a circumstance where the doctrine is something you're looking to. Next slide, please. So the force majeure key concepts really build on the doctrine of frustration key concepts, and it's there to absolve the non-performing party from liability in the event that the event just is too overwhelming for it. The application of the concept is driven by the facts and as I mentioned, narrowly construed. The courts really don't like it when parties wish to get out of a negotiated solution. Basically, a contract is private laws between the two parties. The courts tend not to want to see a party exit from a relationship that they've developed, so they tend to very narrowly determine how that clause is to be applied. They look very closely at the words. But the other facts that they look to are the events itself. How broad is it? What is the impact on that particular party? They also look to the party's behavior. How did that party respond in the face of the event that they've contracted around? And the clause is there to allocate risks to address those events that are beyond the party's control. And I think this is a paramount concept that you'll see in all of these clauses, and I think is really important. That is, and you'll see this framed a lot in the case law, not foreseeable when entering into the contract. There's a little bit of nuance there I'll mention, and that renders the performance impossible. So when I say not foreseeable, it isn't necessarily strictly accurate. The parties may list events that, by definition, if they're listing them, they are somewhat foreseeable. But what is not foreseeable necessarily is the extent of the event or the consequences on that party that arise from that event. Why that event is listed, though, is that the parties have agreed that the likelihood of it is so remote that they're comfortable with placing that riverbank out there, that bridge too far out there. So there's that element of foreseeability, but the consequence of the event is what's difficult for the parties to grapple with. And then the rendering of performance by the non-performing party as being impossible is generally the law in Canada, and really was leveraged a 1975 Supreme Court of Canada case called Atlantic Paper. And the impairment there to the party's performance was basically defined to have to be total. The party is unable to perform its obligations. It's an impossibility for it to. Should mention there is an Alberta case where that standard was very high bar, obviously, has been relaxed somewhat, and it was set to be a real or substantial problem in performing. So not quite that impossibility level for a party to perform, something less. And what that means is that the parties need to be very mindful of their behavior in the face of a force majeure event, or they're deciding that they wish to leverage a force majeure clause that might be in a contract, because they're not entirely too sure what that standard may actually be. Next slide, please. So it's all in the wording. In most of these provisions, you're going to find each of these 5 items. There's a triggering event that brings you into the clause, what happened, that allows you to look at the clause as possibly getting you out of your contractual obligations. There's an impact requirement. Effectively, the supervening event has to have caused the non-performance by a party. It's not some other reason that the party is claiming force majeure. There has to be a direct linkage and causation, and there also is that threshold element to it, which could be specified in the clause, might not be, but you need to have a good handle on what that threshold element may be in your circumstance. There's a mitigation requirement. That's a general contractual provision that underlines all contracts. It may be expressed in a clause, may not be. And there's a notice requirement. You have to strictly adhere to. Perhaps you need to provide notice within a certain number of days. It needs to be in a certain form. And even though, as you mentioned, Vanessa, we've been under this event for now a couple and more months, it's constantly changing. And down the road, who knows what the future may be as we step back from the restrictions that we've put into place. Perhaps there's something else that arises that might trigger a new force majeure event under this concept, where a new notice opportunity may arise. And then there's a relief element. It's not just suspension or termination, but you can define a delay that the parties must acknowledge. There could be cost allocations, there could be liquidated damages. And in technology contracts, there often is a fail-safe over to disaster recovery or business continuity provisions that might come into play. Let's take a look at a specific clause and just let's take a look at that. And I've highlighted those areas that I think go back to these 5 points. You can see this particular clause, if you read it quickly, talks about the triggering event right up the get-go. And it's not unusual to see exceptions to the triggering event as are outlined here. Basically, you don't want a party to leverage its own fault in getting out of the contractual obligation. Next page. And then you can see, next slide, please, thanks, that it specifies that neither party is liable for their contractual obligations in the event of a legitimate force majeure. And here are some of the particulars about how to actually exercise that right regarding notification. Reference to mitigation, you can see a capital M there. So in this contract, mitigation was actually a defined term, so it ran through the entire agreement, and an obligation to continually perform even under the force majeure event, if possible. Next page, and this is perhaps the more important consideration here, is that you can see a linkage to the disaster recovery consequence. It almost, expands quite profoundly a force majeure event. Disaster recovery, those obligations kick off within force majeure, if that is called, or some other event that significantly impacts or impairs the supplier's ability to provide the services. So that's an expansion of the concept of force majeure. And then that clause went on for quite an extensive chunk of the contract. Oftentimes they're separate schedules in and of themselves. But because failure is not an option in technology, critical enterprise functionality might be delivered by that technology. The parties typically are very mindful about how to do that workaround. Next slide, please. The triggering event often is a specific list, as we saw just a moment ago, followed by a basket clause. A little drafting tip here, because everybody needs some Latin on a Wednesday, is justum generis. What this means is that it literally translates into of the same kind. So if you have a list of specific terms, specific concepts, followed by a more general concept, that more general concept will be defined within or applied within the ambit of the specific terms. So in a force majeure clause, for example, if you specified that the specific things that you're worried about are strikes, work stoppages, labor blockades, or something of that nature, and your basket clause, which typically might be along the lines of, or something beyond the reasonable control of a party, if it's structured in that way, that more broad clause would be interpreted within labor-related matters. In other words, you're narrowing the ambit of what you think might be a broad clause by the way it's structured within the clause itself. So maybe the better approach, depending on the effect that you want to have, is to start with a broad clause and then have including but not limited to the following. It's a drafting point that can be very important and surprising. Next slide, please. So the analytical checklist that you can follow for COVID-19. Is it caught by the force majeure clause? That's a technical sort of legal analysis. Is it the cause of the non-performance? And what is the behavior of the parties? Have they tried to avoid that particular event? And if they can't avoid it, what have they done to mitigate it? Is there a workaround solution that takes them out of the application of the clause? What are the procedural requirements? And then what happens? What's the really sought? Next slide, please. So I've listed a number of the contractual provisions that I think the details have already been covered. I think Vanessa did a great job on a number of these items, as did others. But this is where I think you would focus the conversation in the context of something like a pandemic that we're dealing with, where you're going to see some more significant changes that you might have written than you would in a regular negotiation. Certainly, force majeure and business continuity plans in a technology agreement, you'd almost want to start at the fail-safe, the worst-case scenario, the business continuity plan in detail. And so you do due diligence, as Vanessa and others have said, quite deeply on how these things are put together and what are the building blocks of the service delivery and what are the mitigation plans that can be practically achieved. Service levels and the credits associated with those will certainly change. Particularly with cloud agreements, we see cloud vendors sometimes very thin, not well capitalized. Basically, it's a combination of a whole bunch of elements that are contractually tied into the front-end cloud vendor, who's essentially like a reseller. That can be one of the real risks with cloud solution offerings. And sometimes in a circumstance like this, if you don't have line of sight to the building blocks to that service delivery, and occasionally, if you don't have step-in rights and the ability to contract directly with those building blocks, you could be taking on more risks than perhaps you can appreciate. So you can't ignore the due diligence to look behind the wizard's curtain and really understand how the service is being delivered and try to mitigate your risks that way. Integration services termination, some could be on site. Those would be vastly affected by what we're experiencing with COVID. So some writers have said that maybe it's worthwhile, if you have the time, to develop a COVID-19 addendum. Basically, the additional sets of terms and conditions beyond the baseline to account for the fact that service delivery is going to look different right now than it would in the normal course. And the interesting discussion then becomes, when do you off-ramp onto regular service delivery? Is that a third party like the WHO deciding that the pandemic is over? Is that an agreement between the parties where one party may not be particularly motivated to agree? What's that tripping mechanism to get you into normal state delivery services? Next slide, please. So I've got a couple of slides here. Next one on. So all of these, I think, have been spoken to some degree. These are the clauses very much in play that you need to think a little bit more laterally to, in this circumstance, address. For example, payment terms. Are holdback required? Do you need to obtain additional financial covenants than you might otherwise if you are concerned about your vendor's delivery? Is there a performance risk? Change of laws? We're not just talking about legislation, but if a public health authority, is that authority caught by the definition of change of laws that would allow you perhaps to exercise other rights than just looking to your force majeure clause? There are other clauses in a contract that can give you important rights outside the force majeure clause. So look to all of those. Next slide. And things like milestones, change orders, reporting and confidentiality, all are going to change as Vanessa pointed out in depth. And of course, personal information management in these times is going to be challenged. And last slide, so I'll wrap it up with this. Do you really want to enforce your rights? What we're facing right now, obviously, is unprecedented. It's perhaps a bit of a saving grace is that it's not isolated to any of the players along the supply chain. It impacts everybody along the supply chain to one degree or another. And, you know, you might want to be tough and be very aggressive with your contract relative to one party, but you're likely got, you know, inbound obligations too that you're going to have to be responsible for. So this dynamic, in fact, might be keeping people away from exercising these rights that in a different circumstance they might otherwise exercise through force majeure. And I think what we're seeing is a lot more conversation happening that around all of this than might ever happen because of the broad impact up and down the supply chain. I mentioned the Fasken case, which is fairly recent. It came out of Alberta, actually, and it imposed, all contracts have an embedded obligation, implied right, or implied obligation of good faith, to behave in good faith. And that includes in the performance of the contract. And what Fasken did was clarify that there is this duty to act honestly in the performance of your contract. Don't lie. Be upfront, not to your own detriment necessarily, but that underlines, is an underpinning to the concept of good faith. So if you want to exercise your rights, really think about it first. Consider the broader context. Make sure your behavior is reasonable and above board, and just document everything. Don't leave any stone unturned on that front. Back to you, Vanessa. Thank you.
Thank you, Tony. That was very informative and very useful to actually see with our eyes what it looks like into the contract. So today we've learned a lot of important things. We've learned that we have to take care of our digital front window. So we have to make sure that how we deal with our consumers makes sense into what we're doing in our back end. So all of these new IT changes have to be reflected in how we are handling consumers. We have to keep the trust moving with customer. We've learned that IT projects are data intensive, so we need to plan accordingly. We've also learned that there are proprietary technologies, but there's also open source technologies, and they may lead to different contractual provision, contractual considerations that you should be aware of before contracting that type of technology. And finally, we've also learned that IT agreements are there to plan for the worst, but if the worst happens and you have a right IT agreement, it will make your crisis management much easier. We've also learned how to make sure that we learn from COVID-19 situation and that we draft our agreement that are made to survive the future, but also the remaining of the crisis, whether by a COVID-19 addendum or otherwise. And on this note, I would like to obtain every speaker's key takeaway. My personal key takeaway is leadership. I think companies will have to think outside the box moving forward. Difficult times call for tough leadership. It calls for innovation. It calls for changes, for crisis management. These are things that are very hard. It can break a company, but it can also make a company. So the way you're going to handle the next few weeks may be very important for the future of your company. Turn it to Paula. Paula, what will be your key takeaway from today's session?
Thanks, Vanessa. My key takeaway would be just remembering that despite the urgency you may feel to act quickly and implement new technologies, it's still important to take the time to vet vendors appropriately and review those terms and conditions. Make sure you're comfortable with their security processes and privacy practices. And that would be my key takeaway.
Thank you, Paula. What about you, Ariel? Any key takeaway you'd like us to leave it with?
Yeah, I think my my takeaway is on the same note as Paula's to a certain extent. I think we need to remember that despite the urgency of our situation, we need to stay level-headed. We need to remember the importance of contract review, of negotiation, of due diligence, understanding what you're buying and what your rights and obligations are. Certainly needs to be done in an expedited fashion, but those steps can't be ignored in this time. With open source, certainly you need to know what open source materials are being used. You need to consider the impacts they'll have on your other IP or your other contracts, and you need to consider the risks and potential ways to address them.
Thank you. The least but not the last, Tony, what are your key takeaway for today?
Well, I think the last thing that I mentioned in my bit of the presentation is communication. I mean, because of the unprecedented breadth of COVID and what everybody's having to face, pick up the phone. If you're struggling in any way, if you have a supplier that's struggling, just talk it out. It does nobody any good to try to enforce rights and initiate legal action. Particularly in a time like this, and only when it's going to potentially even worsen the situation. Keep the lines of communication open, work around solutions, which would be an implied obligation in any event, and really try to keep the lights on and the business humming as best you can, and help your counterparties do the same thing. It's a way to build goodwill that'll last for as long as you're together.
Thank you, Tony. And I'll take the ball on that because communication is important. You do have our numbers, you have our emails right there. If you have questions, feel free to reach out. I know webinars, you can't really ask questions that are specific to your company. You may have some concerns that you'd like to share with us. That's what we're there for that. You have a phone number, call us. We're all working from home. We're all happy when we get phone calls. We're there to answer. And if you're in doubt, don't stay in doubt. There are many people out there that can support you in this crisis, that can give you their experience doing it before. It's not the first situation that the corporation have been faced. Reach out to mentors, reach out to the industry, reach out to your advisors. And just hold on and kind of try to be as much innovative as you can, as positive as you can, look as forward as possible. And we do hope that you got some insight that may be useful to manage all of these IT projects in this webinar. And thank you so much for your time today.